Oliver Windridge is a British lawyer. He specializes in international human rights, anti-corruption, and international criminal law. He is particularly interested in exploring where these three elements interconnect. Oliver is the founder of Rights Applied, which is a human rights and anti-corruption consultancy that has pioneered the use of multi-track accountability solutions. So with that, I'll turn it over to Oliver and he can begin his presentation. Thank you.
Thank you very much, Lamarck, for that wonderful introduction. I fear sights have been set very high. Yes, so good morning to everyone, or good afternoon, depending where you are. I'm hoping that today we're going to be able to go through in very basic starting point to understand the United Kingdom's recently launched global anti-corruption sanctions regime. I've got a presentation to share with you that I'm going to ask Max to bring up in a minute. And really the idea of today's session is to go through some of the basics of what sanctions sort of are. Many of you probably on this call are probably experts on sanctions. So some of that may be stuff you already know, but just really understanding what sanctions are, particularly in the context of the United Kingdom, because the UK has gone through a number of very interesting and fundamental changes to its sanctions landscape over the last 12, 18 months or so. And then we'll get into some of the detail about those sanctions. And then maybe the most important part, or one of the most important parts, will be how civil society groups and individuals can engage with the UK's global anti-corruption sanctions regime as well. Yeah, you'll forgive me for those who speak Spanish. I have no Spanish, so I'm going to be doing this all in English. My sincere thanks to the interpreter who will be doing this, providing the interpretation simultaneously. I'm going to try and speak relatively slowly so we can get as close as possible to the interpretation and the speaking as possible. And I just want to echo what Lamarck has already said, my sincere thanks to the sponsors and those who've helped put this together, not least Lamarck and Max, who are on the call, who have been fantastic in supporting me. So thanks to you both, as well as ILP more generally, for the invitation to speak. So Max, if we can, shall we get rolling with the presentation and get things going? Great, thank you. So we can probably go to the next slide. So just, I think Lamarck has already talked about this, so I won't sort of double what's already been said, but I'm a British lawyer and I work mostly in that area between human rights, conflict, and anti-corruption, and particularly where we can use mechanisms, whether that's sanctions mechanisms or other tools, to try and push forward with accountability. And you can see the website, and there'll be contact details at the end for my consultancy, Rights Applied. Okay, let's go to the next slide, please, Max. So I think it's quite important, and again, for those sanctions experts on the call, forgive just a little bit of background, but I think it's quite important to understand the background and the concept behind sanctions, particularly in the United Kingdom, as we start to think about how they can be applied by civil society and other groups within the anti-corruption sanctions regime. And I think that will probably be more apparent as we move through the presentation. But I think it's important to note that essentially sanctions come from multiple different places. We have sanctions that come from the UN Security Council. And if you're a UN member of the United Nations, then you are, at least in theory, obliged to impose those sanctions domestically. And up until Brexit, which is when the UK left the European Union, the UK also implemented sanctions through the European Union. And I think it's fair to say that the UK had a leading role within the European Union on sanctions. So the UK led a lot of the sanctions work that you may see happening at the EU level. The EU often refers to sanctions as restrictive measures, but we're talking about essentially the same thing. And so what happened when the UK left the EU, or was preparing to leave the EU, was the UK had to essentially move over all its EU sanctions obligations into domestic UK law. We don't need to go into that too much today because that's not the focus of the presentation. And to do that, the UK came up, or there was a new piece of legislation called the Sanctions and Anti-Money Laundering Act, often referred to as SAMLA. And that's an important piece of legislation because SAMLA not only cut and paste EU sanctions obligations into UK domestic law, but for the first time, it gave the UK the ability to create new sanctions regimes on its own. So up until then, the UK was always operating within the EU. Obviously, the UK continues its obligations as a member of the United Nations, but it has this ability to do its own autonomous sanctions regimes. And so out of that ability came two, what we often refer to as thematic sanctions regimes. So regimes that are not based on countries, but are based on themes. So in July 2020, the UK launched its global human rights sanctions regime. And then, I mean, we're not going into that regime right today in this presentation, but just to note that that came online in July 2020. It had within its scope the ability to sanction individuals involved in serious violations of human rights, including or limited to torture, the right to life, and trafficking and or forced labor. There wasn't a corruption element within that regime. So unlike the US program or the US sanctions regime under the global Magnitsky regime that many of you I think have already had a training on, which covers serious human rights violations and global corruption, the UK's first regime in July 2020 was on human rights only. So following a lot of pressure, following a lot of advocacy, and to be fair to the UK government, the then Foreign Secretary Dominic Raab indicated very early on that corruption would come online as well. We then moved to April 2021, which is when the UK launches its sister regime to the human rights one, which is the global anti-corruption sanctions regime, which is what we're going to talk about today. And just bear this in mind as we move forward in the presentation, as we get to some of the more interesting bits on when sanctions can be applied and how and the context, because this is very important. The UK's ability to sanction individuals and entities is relatively new. We're only talking the last sort of 12, 18 months or so. So this is a new tool in the toolbox for the UK government. And we're going to talk about some of the sanctions that they've used. But that's a starting point to try and understand where we're coming from. Okay, let's go to the next slide, please, Max. So when we're talking about sanctions, generally speaking, what are we talking about? What is a sanction? So the first thing, if you look at the top of the slide, we've got targeted against individuals and entities. This is very important. And again, apologies if for those sanctions experts who this will be familiar to. But often when we talk about sanctions, there's a real confusion between sort of country-wide sanctions regimes, old-fashioned style, often seen as sort of old-school sanctions regimes, the North Korea, the Iran, for example, where entire countries essentially are limited by sanctions. What we're talking about with these thematic regimes and with many of the UK and other countries' country regimes are targeted against individuals and entities. So when we say we're going to sanction somebody, we're talking about them as an individual, and we're looking at them or their companies or those involved or associated with them. We're not talking about country-wide sanctions. These kinds of sanctions are certainly at the moment not something that I think is being considered by many countries or regions. We're looking at going after individuals and using sometimes referred to as smart sanctions or targeted sanctions. That can sometimes be a problem though, because we'll get onto messaging later, but often in the press and things like that, you will see still reference to the country being sanctioned, to the entire nation, rather than the individuals. But what we are talking about is individuals. And the two sort of very basic graphics, which are showing my limited PowerPoint skills, are the types of sanctions we're talking about. So on the left of my screen, I think it's probably the left of your screens, we're looking at asset freezes. So assets, be they real physical assets like homes or cars or even racehorses or whatever, that are in the jurisdiction of the United Kingdom, will be frozen. And money that's in bank accounts also will be frozen. It's important to note, I think, at this stage that the UK's sanctions regimes extend beyond just the United Kingdom, but also to overseas territories and crown dependencies as well, either automatically through the regulations or through parallel legislation that those territories have enacted. So when an individual or an entity is sanctioned in the UK, their assets are frozen. And on the right, a plane, not only are assets frozen, but there will also be travel bans, visa suspension, and if that individual is currently in the UK under some sort of right to remain, that will also be reviewed following a sanctions designation. So you have these two very hard-hitting impacts. Assets are frozen and travel bans are imposed. I would just add a third element to this, which is not necessarily strictly in the regulations, but I have seen through my experience in working in sanctions in the UK. The third element, which is quite important, is that sanctions also disrupt the provision of services. So what I mean by that is when you freeze assets and you impose a travel ban, you also essentially disrupt the ability for these individuals who've been sanctioned to access advice on accounts, legal advice, tax advice, all kinds of sort of professional services. And for those of you who are familiar with the UK, that particularly the City of London is a multi-billion-pound industry for the provision of services. Now, some of those services, for example, legal services, you can apply for a license to have funds released in order to pay legal bills and what have you. So it's not a disruption entirely, but I have seen time and time again this sort of additional impact of disruption on services. And for London and for the UK, that is extremely impactful, I think, on targets as well. So just keep that in mind when you're thinking about the impact that sanctions can have on individuals and entities moving forward. Great. Let's go to the next slide, please, Max. So those keen observers of what I was saying earlier would have mentioned that when we were talking about human rights, the human rights regime was limited or is limited in scope to right to life, torture and trafficking. The global anti-corruption regime is also limited in what it means by corruption. So this is a bit of a sort of, this is not a technicality, but just to observe, the UK, when it's launched these thematic regimes, has made I think this is not controversial to say, intentionally limited the scope of what it means by corruption and human rights. This is subject to ongoing advocacy by civil society groups. It's certainly, as I understand it, subject to ongoing consideration by the UK government in terms of potentially expanding the definition of corruption. But it's very important at the sort of the early stages to understand that corruption is relatively limited in the UK's anti-corruption regime as compared to, for example, the US regime, where corruption is much widely defined. It's defined in the UK as bribery or misappropriation of property. So when we're thinking about making a submission to the UK anti-corruption regime for sanctions, the first thing, or one of the first things we need to think about is the corruption, is the behavior or the conduct either a bribery or a misappropriation of property case. And thankfully, the UK's regulations go into some detail on what the definition of those two conducts are. So if we go to the next slide, Max. Thank you. Bribery is defined in the regulations. And by the regulations, I mean the UK's global anti-corruption regulations. To include both giving a financial or other advantage to a foreign public official and a foreign public official receiving a financial or other advantage. It is relatively widely defined, and if you compare the definition of bribery under the UK anti-corruption sanctions regime to, for example, the Anti-Bribery Act in the UK, this is a slightly wider definition. But this is what we're looking at. So when civil society groups are starting to look at whether or not a case would fit within the UK's anti-corruption regime, this is the definition of bribery that you need to look at and see if the evidence or the underlying information fits with this. And we can find that in the regulations as stipulated there. If we go on to the next slide now. Thank you, Max. The definition of misappropriation of property. Misappropriation of property occurs where a foreign public official improperly diverts or allocates property entrusted to them in their official role. It may be intended to benefit them or a third person. Property means anything basically of value and can include contracts, licenses, or concessions. So again, a relatively wide definition of what is meant by misappropriation of property. But again, when we're thinking about corruption in terms of submissions to the anti-corruption regime, we need to be hitting either the bribery or the misappropriation of property definitions in order for it for a submission to be in scope, to be within the remit of the regime. Like I say, there was a lot of talk about how far that definition of corruption would extend. These definitions are found in lots of different places, but within the UN Convention Against Corruption. And as I understand it, that was sort of the thinking behind it, was to start off with two relatively well-established, well-defined, well-recognized forms of corruption, with the ability to move forward and expand that if and when it's appropriate. But this is what we have at the moment. This is the framework in which we work. So this is where we are, where we need to be focusing our attention in civil society submissions. Great. Let's move to the next slide. So I guess if sort of as an overview, if you think of the scope of the regime as being relatively limited, as corruption meaning bribery or misappropriation of property, the involved person test, which is essentially who can be sanctioned for bribery or misappropriation of property, is extremely wide. And this is very small on my screen, so you don't feel like you have to read this all, but the general concept or idea is that whilst, yes, the conduct is going to be limited to those two forms of corruption, the UK's global anti-corruption sanctions regime has an extremely widely cast net to go after not only those who, if you see at the first bullet point, not only those who are responsible for or engage in corruption, but also, as you can see in the bold sections, those who facilitate, support, profit financially, conceal or disguise, transfer, or fail in their responsibility to investigate or prosecute, or use threat, intimidation, or physical force in sort of against the investigation into these kinds of cases. It's very widely drawn, right? So you're not only looking at sanctioning those individuals who are themselves, let's say, arranging or bribing people or misappropriating property. The regime allows the UK to sanction a large cast of individuals and entities who are also involved in that corruption as well. And when we go on to look at some of the examples that we've got from the UK, you'll see that the UK, the Foreign and Commonwealth Development Office, FCDO, who are the pen holders on the sanctions regime, this one and others, have used this very wide definition of an involved person to go and sanction individuals, not only who are directly doing the corruption themselves, but all of those around it as well. I think that's very important to understand, is that we can use this sanctions regime to target enablers. We can use it to target individuals who may be preventing prosecutions or investigations, and really go after the entirety of a corrupt system. And then the final section on the slide there is that an involved person can also include essentially companies and entities who are owned or controlled by the person who is the involved person, or is a member of. So this also gives the UK and the ability, and I haven't got a slide here on what owned or controlled means, but there's a sort of two limbs to it. It's either 50% plus of sort of shareholdings, or an ability to control and that business or entity. And again, I guess the takeaway from this session is that this again allows the UK to use this sanctions regime to go after individuals and entities who are controlled and owned by a person who's involved in corruption. So again, a wide net can be drawn, and you can, at least in theory, go after a large group or a large number of targets, not just one particular individual. So this involved test is much wider as compared to the definition of corruption, which is relatively limited. Great. Max, let's go to the next slide. This is an important point for us as groups in civil society to understand the legal test for an individual to be sanctioned. Two elements to this, and it's the global anti-corruption regulations, but it's also applicable to the human rights regime and country regimes as well. And that's that you have essentially these two limbs to the legal test for how, or in order for a person to be sanctioned. The first is that there are reasonable grounds to suspect that the person is an involved person. Involved person as in what we've just seen in the last slide. So that's a very wide net. First thing to note on this test is the reasonable grounds to suspect standard. So we're talking about here is a lower standard than a criminal case, for example, beyond reasonable doubt or something like that. The standard is that the UK, the FCDO, the Foreign Secretary, has to be provided with evidence or meets the test that reasonable grounds to suspect that the person is involved in the ways that we've discussed. So it's a lower standard. That goes with the idea that sanctions are a foreign policy tool. They're not a judicial tool per se. It's a decision that's made by government, by the Foreign Secretary in almost all cases. And so you have this lower, sort of akin to civil standard. The second limb of the test is equally as important, and something that I often really emphasize when we're talking about this regime, and that's that designating the person, the involved person, would be appropriate with regards to the sanctions regime. the purposes and the likely effects. I think this is really important to emphasize, particularly for civil society groups, in my experience, because the first element, I think civil society groups are very good at providing evidence and information that a particular individual is involved in corruption and that it would meet that standard of reasonable grounds to suspect. That's what a lot of civil society groups, TI and others do on a daily basis, is gather information and publish it and provide that information that demonstrates, beyond, well, certainly reasonable grounds to suspect that this person's involved in corruption. So often that is not a particularly big lift for civil society to provide that information. It still takes some work, but it's often there or can be found. This second element is one that in my experience, is equally important, but requires a little bit more work, particularly from civil society groups. And that's the arguments that have to be put forward in a submission that sanctions are appropriate, right? So we can say, well, the evidence we've provided you clearly shows that this individual is involved in corruption in one of the ways under the framework of the regime. But you have to convince the Foreign Office, the Foreign Secretary, that it's also appropriate that sanctions are used as opposed to another form of another tool in the toolbox, as opposed to diplomacy, as opposed to working behind the scenes, as opposed to working with local law enforcement or international law enforcement, as opposed to working on an international justice element, just a few examples there. But why is it that sanctions would be appropriate? Why is it that freezing assets, travel bans would be the most appropriate tool in the toolbox? So, I don't want to spend too much time on this, but I do find that this can often be a challenging matter because, civil society is very good at saying the person's corrupt, it's obvious. But why is it that this tool is the most appropriate one? And we have to tackle that in terms of a sanctions submission to the Foreign Office. We have to be able to convincingly argue that sanctions are a good reason. And those reasons, we'll go into them in a minute. There's some policy guidance that the UK FCDO have provided. But it is things like, well, it's appropriate to sanction them because there's going to be no action in country. Either the police are involved in the corruption, or they are simply ineffective, or in some way incapacitated. There is no other forms of accountability provided at the regional level. Either the country doesn't engage at regional bodies or international instruments, human rights instruments, or corruption instruments. It's appropriate to sanction them because they have significant assets in the UK. So if you actually sanction this person, you would freeze a significant number of assets, and that would have a real impact. Or it's appropriate to sanction them because this person very regularly, comes to the UK, spends their ill-gotten gains in the UK, and so sanctioning them would have a direct impact. I'm not saying it's necessarily difficult to get over this appropriateness test, but it is something that needs a significant amount of thinking, and it needs to be addressed. Okay, let's go on to the next slide. So here I want to give some examples. So the regime launched in July, and we have had 27 designations as of right now under the global anti-corruption regime. Of those 27, I've pulled out a few which hopefully are most appropriate and most interesting. I mean, I'm sure many of these will be familiar to people who are attending. We've had one from Honduras, one from Guatemala, and you'll see on both of these cases. What I've done here is I've cut and paste essentially the explanation for the reasons given for the sanction from the UK's decision. So it's all public, it's all provided. We have also Nicaragua and two from Venezuela. And I'm not going to go into detail on each of them. Many of you will be familiar with these cases, but I think it's important to note, first of all, that the UK has used its global anti-corruption sanctions regime on cases involving Latin America, South America. A relatively wide geographical scope, as in 4 different countries, which is, for the UK, relatively sort of notable, I think. And for slightly different and interesting areas that these individuals have been sanctioned. And so, taking these cases, the diversion of public funds, the facilitation of it, in all 4 cases, and these are all publicly available. These are all available on the UK website with this explanation given. This is the only reason that the UK government will be like often just a few sentences of why it is that the person's been sanctioned. But just to give you a flavour that there has been some sanctions out there for the region, and like I say, many of you are probably both very familiar with these cases and may well have worked on these individual submissions themselves. So to take away from this, just, there is scope, and I think there's also interest from the UK government moving forward to use this regime across the world, across the globe, in various different areas, including Latin America, South America. Okay, next slide, please, Max. So now I thought we'd just spend a few minutes now getting into the making an application. So essentially, civil society groups, anyone can make an application to the UK Foreign Office, to the FCDO, make a filing. There is no set template that the UK government gives. At a minimum, it obviously needs to have who the person is, and particularly identifying information if you've got passport numbers or date of birth, that kind of information. And then you need to engage with the regulations. So you need to actually engage in any application to say what it is that justifies the application of sanctions. Identify the activity that constitutes corruption as defined under the regulations, and also identify how that person is an involved person. I will say that in my experience working on civil society applications to the FCDO on a number of different countries, the more information you can provide, the better, I think. You have to realise that the UK's sanctions team has many sanctions. The reality is that they will have many submissions. They will be looking at lots of different cases. I think it's fair, and I mean, I'm not obviously talking on their behalf, but I think it's fair enough to say that they don't necessarily have the scope to go and spend a lot of time doing detailed research into each and every case. So if you provide only, say, like a name and a date of birth and very little other information, I think it's reasonable to suspect that the FCDO will not, their sanctions team will not have the capacity to go and dig into that. The more information you can provide, the more information that can be set out in a detailed and accurate manner, particularly within the regime and the regulations, pointing back as often as possible to how it's defined under the regulations, is only going to help your application, is only going to assist the FCDO sanctions team in understanding your submission and understanding what it's for. So while these are a minimum, I really would stress that these are really are a minimum, that what we're really talking about is being able to provide information, provide underlying information. We'll get into this, preferably open source. We're going to deal with that in a second, but really provide as much information. And myself as a lawyer, I really look at these things almost like a legal submission, the same way that if I was making an application to a regional human rights court or an application to a UN mechanism, I would want to have that set out in a very structured way, an executive summary, an introduction, application of the regulations and a conclusion. It's really setting it out, applying the regulations to the facts. I think, in my opinion anyway, while it's not necessarily specified by the UK as a requirement, I think it's really important that civil society does as much as they can to put these regulations, or to put these submissions, sorry, in with as much detail as possible, essentially helping, almost making it impossible for the FCDO not to, at least move the case forward and potentially sanction an individual. Next slide, please, Max. So really, when I was talking about some of the reasons why we're talking about appropriateness in that two-limb legal test, you have the first limb, which is reasonable suspicion. The second one is the appropriateness. And the UK, the FCDO has published a very helpful policy guidance, which essentially sets out 6 reasons. They're not the only reasons, but 6 important factors for where the UK will use its anti-corruption sanctions regime. It's its anti-corruption policies, the scale and nature of the corruption, the status of the individuals involved. Collective international action is where essentially can the UK, Canada, US, all act, and the EU act in concert to do sanctions at the same time. That's often an attractive proposition. Interaction with law enforcement activities or not, as the case may be, and risk of reprisals for civil society. So very briefly, these are the kinds of points that you want to be hitting when you say, yes, it's appropriate for the UK to use its sanctions regime in this case, because it fits with your anti-corruption priorities, and they're available online. I can provide those. This person is a high status, well-connected individual. It will have a great impact on not only on that individual, but on the entire sort of structure of a corrupt system, for example. So you can, again, I would encourage any civil society application to engage with these policy points that the UK government has provided and use them. Use the UK government's language in your submissions, so it's very familiar to them. So it's familiar to the sanctions team, that they understand what is being argued and what is being provided. Should we go to the next one? Okay, 2 points to make on this as we move forward. Unlike the first point is on appeals, which is quite important as it goes to sources and it goes to just the general understanding of sanctions in the UK. Unlike in the US, I've been involved in a number of sanctions applications in the US where the opportunity to appeal, this is the appeal by the person who's been sanctioned, so the designated person, is relatively limited. In the UK, there are very clear opportunities for the individual to appeal their sanctions designation. The first is a right to appeal to the minister who made that application. This is all in the SAMLA, so the Sanctions and Anti-Money Laundering Act, the overarching piece of legislation. And essentially there you're going back to the Foreign Secretary and saying, I shouldn't be sanctioned. I would argue that that's unlikely to be a successful avenue in many cases. I think that's probably only likely to be successful moving forward in cases of sort of mistaken identity, where you say, well, you wanted to sanction, Oliver Windridge, who lives in this country or is involved in this corruption in this country. You sanctioned me, I'm a different one, I've nothing to do with it. So there's administrative errors where you have those kinds of administrative errors. You may see a successful appeal to the minister. More likely, that appeal is going to fail if it's simply on the case of I shouldn't have been sanctioned type thing. But it does allow a sanction an appeal to the High Court, where you are then dealing with an independent High Court judge. The High Court judges obviously don't work for the UK government, they don't work for the FCDO. So there, a case can be appealed. And, from my understanding, there are a couple of cases that are currently, if not at the High Court yet, but certainly in the sort of route towards being appealed. The reason I mention this is because, first of all, it's important to understand that individuals who are sanctioned do have this ability to appeal their their designation, they have the ability to challenge it, to say, no, the UK got it wrong, I'm not involved in this corruption, or I'm, I don't meet the involved person test, for example, or something like that. But it's also important for the second point on this slide, which is protection of sources. Again, unlike the US, which has a much clearer and stronger ability to essentially anonymize or make confidential the information that it that's provided to it by civil society groups. That is, if not entirely sort of clear at the moment, if I'm being totally honest, with the UK. What we are being told by the UK government, and I think it's good advice, is that the information that you provide as civil society groups to the UK should, in wherever possible, be open source information. So a bit like the EU has this sort of very clear open source only sort of policy, the UK is saying something relatively similar, which is we want to base our sanctions designations on open source material. And one of those reasons, and the most important reason, is because when if a case gets appealed and it goes, for example, to the High Court, it goes to an independent judge, we will do everything in our power to protect the source of that information where possible. But we can't tell a High Court judge what to do. And if the designated person were to make persuasive arguments, that they require information, then a High Court judge may well order that disclosure. So where it can't be 100% guaranteed that sources can be protected, open source information obviously negates that issue and makes it very obvious or very clear that that's not going to be an issue. Where there is confidential information that really civil society groups feel would either strengthen or really bring home a case, then there is the possibility of filing that information with the Foreign Office. That can be done. It can be done in a way that you can anonymize it. You can it's literally write confidential on the top, that would allow the FCDO to try and protect that information. But I think we have to be clear that whilst this regime is in a very early stage, while it hasn't been challenged yet, as far as I know, in the High Court, we're still waiting to see how the court and the High Court will deal with that. Now, if there are very, very good reasons why a source should be protected, concerns over life or serious harm, those kinds of things, I would argue that there's a good chance that the UK would, I'm just seeing Dion's message, that the UK would, the Foreign Office would prevail and would succeed in any application to the High Court. They would say, look, we can't provide the information. But I think it's only fair, and I think we have to be clear about this, that with that confidential kind of information, there has to be a clear understanding that it's not guaranteed, at least until we've had a few cases go through the High Court, where we can rely, where we can then say, the High Court, is consistently applying, this kind of confidentiality measures. So we have to be clear about that. It's particularly important in my experience, and I don't want to preach to the converted here, but or those who are on the ground, but it's particularly important, I think, for the smaller civil society groups in country. So where you're talking about larger international groups who've already published information, I think there's a degree of protection, even if it's confidential information, that comes out, that though that organization was the source of that information, there is some sort of, it may be not as impactful as dangerous. Where you've got, particularly smaller groups, smaller civil society organizations that work in country that can't rely on their sort of international status, then it is a significant concern. I would say, don't let it necessarily put anybody off from filing a submission, or at least exploring it. Look at what you've got in terms of open source information, look at what's available. There may be enough information there anyway to get to the standard of reasonable suspicion to believe. If there's something that you really feel needs to be included, but it is confidential, then, you know, reach out and discuss it. Don't file it with the Foreign Office before FCDO before discussing it. But there are ways that that information, you know, can be protected, or at least so try and work around it. Try and see if there's a way that that information can be provided in a way that would protect you. But I totally understand that. That's why, I mean, it's on the slides. Protection of sources is such an important issue for civil society. But last point on this would be, you know, in all my conversations with the FCDO sanctions team, they very much recognize the role of civil society. I think it's fair to say, I mean, you know, I'm not talking on their behalf. They may want to correct me if they ever see this, or, you know, there's people on the call, but they do recognize the ability or the role that's played by civil society. So, you know, they are looking for ways, I think it's fair to say, to ensure that information that's really important can get to them in a way that would protect the sources, but also comply with the rights of those persons who are designated as well, to know what is the underlying information under which they've been sanctioned. So there is a certain degree, I think it's fair to say, of you know, important sort of collegiality going on at the FCDO in terms of recognizing that. But I think a lot of this comes down to the point that if this were to come to a High Court judge, if this were to come to a an independent you know, body, you know, we're then in the hands of others, and therefore the FCDO can't, I don't think, really provide a 100% guarantee at the moment until we've at least had a few cases to go through. But happy to pick up on that more in Q&A when we get there. I don't know, do we have any more slides, Max? I think we probably
yes.
do. How many more have we got? How long have we got to go? How long have we got for the whole session?
We've got until 2:30 UK time, so we have another.
Perfect. So we can spend a few more minutes on the slides, and then we'll have a good, hopefully a good half an hour or so for Q&A. Thank you, Max. So if we go to the next slide. So this is how my brain works. Maybe other people on the call, you know, I'm sure are much smarter than me and can get this a lot easier. But essentially, what I wanted to do was provide a very basic sort of checklist from all the information that we've talked about in this session in one place, so you can start to think about it in terms of how the anti-corruption sanctions regime may be applicable for cases that you work on. So if we start on my left, probably your left too, which is the entities. So just to reinforce again, the global anti-corruption sanctions regime in the UK is applicable to persons, companies, organizations, and other entities. So the scope of the involved person, if you remember from that slide, goes wide, and it goes to all different kinds of basically people and entities. The corruption element, which is the second one along, corruption is defined as bribery or misappropriation of property. So when we're saying we've got a corruption case that we want to take to the UK, to the FCDO sanctions team, is it either a bribery case or a misappropriation of property case within the definitions of the regulations? It's important to work off the regulation definitions rather than other definitions. Because A, they're wider in some cases, and B, they're the ones that the sanctions team themselves will be looking at. So if we've got a relatively limited scope of the corruption definition, if we go to the involvement one, you know, it's very wide. So, you know, we can say it's a person, they're involved in misappropriation of property. How are they involved in that misappropriation of property? It may be through, like, doing it, you know, being responsible and engaging in it, but it could be through all these other ways: facilitating, profiting from, sort of transferring or moving proceeds of the conduct, failing, you know, involvement in failing to investigate or prosecute, involved in sort of intimidation and threats and physical force against individuals who are involved in investigating, or in some way contravening the provisions in the regulations. So I guess the takeaway from that section is the involvement of the person can be very wide. So if you get a case that says the person's involved in the bribery, but they're not, they're not bribing people themselves, but they are profiting from the bribes, that's still covered under the regime. So always be looking at the involvement. And I think this goes to when we're filing submissions, there has to be obviously some tactical decisions made about who is the targets are that you actually put down. But you can be multiple targets. So you can say, we're putting forward three individuals for consideration. Not only the person who is, directly engaged in the bribery, but also the person who's been, providing support through, however, and also the person who has been transferring the proceeds of that bribery. So you can start to build up a sort of a network of of individuals who may fall under that kind of involved person test. And again, just to sort of reiterate, from my discussions with the FCDO sanctions team and being on calls with them, I think it's fair to say they're very interested in how this regime and the human rights regime can be used to go not only after the principal offender or the principal person who's involved, but also the enablers and those who are involved in the network as well. So, something to consider as well is where are there appropriate sanctions or targets? And then you get into your appropriateness test as well. There are individuals, maybe the person who is transferring the proceeds themselves has significant assets in the UK. That again might tip the balance in terms of putting that person on your sanction submission, because the appropriateness test would also meet them and their role in it. And then finally, on the right, again, just to emphasize again, to use the language, the UK FCDO has provided a policy paper, it's provided a guidance to NGOs, use that, not only use those policy papers and guidance, but I would argue, use the language in them, because you're then essentially directly quoting back to them the very language that the team will be using itself. And, in many cases, the sanctions team who you send it into will be the very same people who drafted the policy paper. They'll be very familiar with it, and they'll be probably very pleased to see that submissions are directly quoting them, and they're using that kind of information. And so, as you start to build up the appropriateness of, or the potential for a sanction submission under the global anti-corruption regime, this I would say would be a relatively useful. It's by no means exhaustive, but a relatively useful sort of tick box exercise to start to move across and say, well, does it meet these kinds of tests? Does it meet within the involvement, the definition of corruption, and also these sort of key policy issues as well? Because again, we can talk about this in the Q&A, but the UK has a number of different tools in its toolbox. It has different ways of engaging on issues of corruption, as with other foreign policy issues. And this is really a key issue, is why is it that sanctions, and it's not easy, but it's relatively straightforward to make those submissions. But again, like I said earlier, in my experience, civil society groups are often very good at providing the information that provides the first limb of that test, which is that it happens, this corruption is going on. Can be more tricky sometimes to address that issue of why it's appropriate that sanctions, as opposed to other tools, would be appropriate. So hopefully that's quite useful to sort of frame things out as we move towards the end of my presentation. Max, do we have any more slides? Oh, that's me. You can follow me on Twitter, and you can email me on Proton Mail. I've got a secure email, and please feel free to reach out. I've also put at the bottom there the UK Anti-Corruption Coalition, of which One of the organisations I work with, the Sentry, which is an organisation that works predominantly in Central and East Africa. We're a member of the UK Anti-Corruption Coalition, as are a number of other civil society groups who I think may be on this call. But again, if you're interested in learning more about either the UK anti-corruption regime, or more generally speaking, what's going on in the UK in terms of anti-corruption, both domestically and internationally, I would encourage you to go to the UK Anti-Corruption Coalition website as well, because there's a lot of information there. And there's also information there of other members and how you can get in touch with them and how they may be able to help you moving forward as well. But I think this is the end of the presentation. I hope we've managed, albeit quite briefly, to go through some of the major points on this really interesting and exciting sort of new anti-corruption tool that the UK has.